appeal of Water and Sewerage Corporation against Carla Anita Cecilia Braynen Turnquest.
Yes. Mr. Roger?
Good morning, my lords. I hope everybody can hear me well. If it pleases you, my name is Devon Rogers. I appear before you on behalf of the Appellant Water and Sewage Corporation of the Bahamas. With me, I have Ms. Catherine Bailey. On the other side, on behalf of the respondent, Carla Anita Cecilia Braynen Turnquest, you have Crystal Roll, KC, and with her, you also have Mr. Darren Cash.
Yes, thank you.
For the record, my lords, I just want to confirm that you have before you the reproduced record. Also, there's the written case filed on behalf of the appellant and also the written case filed on behalf of the respondent, which substantially, I guess, flushes out the respective parties' positions as regards to the appeal. In addition to those documents, my lord, we just recently, I apologize, my lady, my lords and my lady. In addition to those documents, my lady and my lords, we recently added to the reproduced record a A3 color version survey plan, dated 24th May 2011. That was the plan that was conducted by one of the witnesses in the matter, Mr. Emile Leday, and also missing from the reproduced record was the second page of a letter authored by Mr. Gilbert Thompson and dated the 16th of November 2018. So we sought to, although it did not make it part of the reproduced record, it's my understanding that that was just recently filed with the Privy Council.
Yes, 16th November 2018, is that what you said?
Yes.
Yes, we have that.
That's right. And that letter, just for ease of reference, would be found at page 134 of the e-bundle.
Right. Yes.
To continue, today we're here today on the appeal from a Court of Appeal decision from the Bahamas, where we're seeking to challenge the court's determination that even with defects, the respondent's documentary title was better than the appellant's possessory title. It's our position, the appellant's position, that the Court of Appeal plainly got it wrong. And we say that the Court of Appeal should not have interfered with the decision of the learned trial judge as her determination that the respondent did not have a good root of title, which was relied on by them, documentary title. We say that she got it right in that there was no good root of title, and we're going to explain exactly why we say that. And we say that based on the law and also on the facts and evidence that was before her, she had good reason to come to that determination. With that said, I'd like to speak to the flow of our arguments at the outset, just to give you an understanding as to the direction that we're going in. First, I'll be talking about the root of title and the need to prove a good root of title. The documentary title that's being relied on by my learned friend is the 1963 conveyance. That was a conveyance between the respondent's grandfather, the respondent's grandmother and her father, the grandmother acting on behalf of the estate of her grandfather. We say that the conveyance itself was null and void, because it failed to properly describe the property in question such that it could be readily identified. And also
that
we
doesn't make
say,
it null and void. It just means
well, sorry,
it's-
it was wholly defective to the point where it does not exist, that she did not have any root of title.
well, and that depends upon the parcel clause.
Yes.
And so, but the judge at paragraph 151 identified that the water tanks was on the property.
Yes, my lord. She identified that based on their representation that they own that property for the purposes of trespass.
Who owns what property?
Sorry. Based on the respondent's representation that this particular piece of property that water and sewage was on was their property, the judge was saying, looking at the survey plan that was prepared by Mr. Emile Leday, she did think that we were trespassing on their property, but she's not saying that, but she didn't find that it was actually owned by them at the conclusion of her decision. So in other words, they're asserting that they own that property based on their 1963 conveyance, but as she's saying, okay, if you do have it right, you are on that property. But at the end of the day, my conclusion is, my determination is, that the documentary title that you rely on is wholly deficient and thus cannot be relied on as a good root of title, and thus your claim must fall.
Well, that's two different things. She said that the 1963 conveyance was not a good root of title because it wasn't based on earlier roots of title going back to the grant by the Crown. But I think the point that my lord was making, which is a point I've also been thinking about, is you're making now a different point, which seems to be that it's not clear what land was included in the conveyance, whereas the judge seems to have made a finding that the water tower was built on land which Mrs. Turnquest does say was the land conveyed, and she seems to have accepted that, the judge, but her problem was, well, do we know that your grandfather had title to that land from earlier conveyances? Isn't that a different point you're making?
Well, my lady and my lords, the point that I intend to make and what was made in the case below, and also which the judge did rightly respond to, first and foremost, she found that there was no good root of title based on the fact that there was no document that connected the Crown Grant F-28 owned by Joseph Evans to Mr. Albert Brennan, the grandfather of the respondent, and consequently, that was a sufficient flaw whereby there was no good root of title. The second point that she raised inside her judgment...
And can you just assist us to follow this? Which paragraph have you just been, of the judge's judgment, have you just been referring to?
If please, your words. At 147,
Yes.
well, sorry, if we go to page 712,
Yes.
there's two factors that I was going to raise, right? So the first one would be 142. Reliance on the 1963 conveyance is also questionable as there is no plan attached to describe the property referred to, nor is there a proper description of property. Now, when we look at the test that the judge ultimately relied upon, which is contained at paragraph 147, sorry.
Sorry, could you pause for a moment? I can't.
We've got a... Sorry, if you could just wait. We've got a technical issue.
Okay. Yeah. Well, as long as that was oh, sorry.
Are you... Do you want to...
Yeah, could you just back up a little bit? So what were we were looking at some paragraph of the judgment.
At paragraph 142, I'd asked counsel to give us the reference in the judgment to support his statement that the judge had found that no document connected the Crown grant to Albert Brennan, and 142 is what you pointed us to. I'm not sure that 142 is making that point, is that?
No worries. I actually was doing it in reverse order as to why we say the judge found that there was no good root of title. We say that she found that there was no good root of title relying on the common law test as set out in paragraph 147. And there's two factors that she took into consideration and made pronouncements on. The first is that if I could take you to the definition, if you don't mind.
Yes, of course,
I'll take you to the 2 points that I say that she relied upon to make her determination. It says root of title is not defined by statute, which I highlight because I think that's very important.
You're reading from the quotation in paragraph 147, is that
Yes,
right?
yes,
Yes,
Lord.
got you. Thank you.
And it goes on to say, Williams on the vendor and purchaser, 4th edition, provides good definition of what constitutes a good root of title. The author states at page 24, must be an instrument of disposition dealing with or proving on the face of it without the aid of extrinsic evidence the ownership of the whole legal and equitable estate in the property sold, containing a description by which the property can be identified. So in this instance, she drew her attention to the fact that it must have a description that readily identifies the property. And then it goes on to say, and showing nothing to cast any doubt on the title.
Right.
And so we say that if we go to page 140, paragraph 140, which is page 711, and I read, a review of the aforementioned title documents reveals a large gap between the Crown grant to Joseph Evans and the large gap between the Crown grant to Joseph Evans and the 1875 Sweeting will. There is no evidential connection between the two, and it begs the question of how William Sweeting came into possession of the property. Moreover, the probate documents filed in the estate of the late Albert Brennan make no mention of the property as being property owned by the late Albert Brennan. Further, there are no documents submitted which show how the property came to be owned by the late Albert Brennan.
But that, if I may say, that seems to be a different point. I thought that reason that you were showing us the definition, common law definition of root of title with the underlined words in paragraph 147 containing a description by which the property can be identified, went to the 1963 conveyance, and you say there isn't a description which can identify the property, whereas paragraph 140 seems to be looking at possible gaps in the chain of title leading up to the 1963 conveyance.
That's what I'm saying. Our attack on our support of her determination is two-pronged. We're saying that she made findings on both points. So in other words, the first point that I just brought to your attention, 140, deals with the fact that based on the evidence before the learned trial judge, there was no documentary evidence whatsoever that proved how Albert Brennan came into possession of the property that is now being claimed by the respondent, such that he could convey that property by the 1963 conveyance to Mr. Carl Brennan, his son, and the father of the respondent. So basically, based on the words of, and showing nothing to cast any doubt on the title, we say that the learned judge did find something to cast doubt on title, because there was no document that showed how Albert Brennan came into possession of the property being claimed, or came into ownership, sorry.
Yeah, I mean, as I understand it, your attack is two-pronged.
Yes.
One, the documents do not identify what was conveyed, and that's what I thought was being said in 142, for example. In other words, there's no description of the property sufficient to identify it, which is the point underlined in paragraph 147 in the citation, in paragraph 147, which is a question of what is the land. And then the second is there's nothing to connect the person alleged to have conveyed it in the 1963 conveyance to anybody who previously owned part of the land. So as I understand it, you say there were two problems. Can I just pick up one point which got mentioned a little bit earlier, which was that this judgment seems to use the word property with a capital P fairly indiscriminately, both to refer to, I think, the very land on which the water tanks are situated, but also land in general, because Lord Stevens referred you to, for example, paragraph 151. At the end of paragraph 151, where there is the sentence, in addition to Plan 600 AN, there is evidence agreed to by both parties which showed that both parties accepted that the defendant's water holding tanks and storage were situated on the property with a capital P. Can you just help me? What is that supposed to, what do you understand that to be saying? What was the agreement? Because property with a capital P, the judge defined right at the very start of the judgment in paragraph 1. But in a way that doesn't make it clear to me what that finding at 151, if it is a finding, is intended to mean. And you can see the indiscriminate use of the word property with a capital P in paragraph 142, which you referred us to, because it said reliance on the 1963 conveyance is also questionable. There is no plan attached to describe the property referred to with a capital P. And that can't mean property with a capital P. I'm just trying to play catch up for a moment to try and understand what actually was agreed as and what wasn't, and what the judge found in 151. So if you can help me to try and catch up, that would be very helpful.
I follow. I understand. I think in this instance, where she refers, at page 151, she's referring to the specific area upon which the tanks are located.
And by specific area, you mean literally the road and exactly where the tanks are fenced in, but that's it?
Yes. And then in the earlier part, paragraph 1.
Sorry,
when she refers to
sorry, I'm not sure that I followed your answer in relation to 151.
She's referring solely to the water holding tanks and storage. It doesn't refer to the road at all.
No, this is just the water holding tanks. As there's a picture of them inside the bundle, if you want me to take you to, just so you can have an idea as to what we're speaking on.
But she's saying they were situated on the property.
And that both parties accepted that they were situate on the property.
And I have to say, I
This
read the
is-
property
this
there
is-
as using the definition that she set out in paragraph 1.
But the reason for this is she's just, the evidence that was led during the trial by Mr. Emile Leday, we went through extensive trial and many questions as to how he plotted the 600 AN plan, survey plan. He indicated that he had to he didn't rely solely on the 1963 conveyance.
He did or he didn't?
He did not rely solely, and he did not rely solely on the will. In fact, it was the evidence before the court and the submissions of my learned friend during the trial that, in fact, he didn't rely on the will of William Henry Sweeting, which is referred to in the 1963 conveyance. He didn't rely on that at all to map out the plan, even though the 1963 conveyance...
Even if there are inaccuracies in a parcel clause in a conveyance, you can call extraneous evidence to try to sort out those inaccuracies. And so the fact that they called other evidence that wasn't in the, as it were, in the documentary title, is neither here nor there.
Well, we respectfully submit that in this instance, the question was whether or not in terms of a good route of title, whether or not, based on the 1963 conveyance, one can readily identify the property. While
It's got to contain a description by which the property can be identified.
Yes.
And you can identify it in numerous different ways. But the question basically is this: do you accept that the judge made a finding that the water tower and tanks were on the property conveyed in the 1963 conveyance?
If I may refer you to page 508.
Sorry?
508 of the bundle.
We're moving away from the judgment, but my Lord's question, I think, was directed to what the judge said, in particular, my understanding, paragraph 151.
So this is the statement of agreed facts that was before the trial judge?
Yes.
All right. Sorry, could you give us the page number again, please?
508 and 509.
509.
508, 509.
In particular, I refer you to paragraph 5, which states, we do not accept that the subject land is a portion of the land referred to in the 1963. So that was always a part of our challenge.
Yeah,
So then the question is, did the judge find against you on that?
as I understand it, you do not accept that the water tanks are built on land, I'll use the word land to avoid using the word property, because I think there's a problem with using that, conveyed in the 1963 conveyance.
That has always been our position.
Right. Can I, to pick up my Lord's point, if we go to paragraph 1 of the judgment, the judge quotes from the pleading and defines the property with a capital P as a portion of the original Crown grant situated on the eastern side of Wellfield Road, approximately 1,697 feet southwest of the intersection with the main public highway. Well, that is a very specific distance southwest of the intersection with the public highway, and then my understanding is that is just designating where the tanks are situated. If you look at the plan, it's fairly clear. All that is saying is that the definition of, quotes, the property is just where are the tanks situated. Because that's what is 1,697 feet southwest of the intersection. She's not defining any wider area of land. The definition that the judge has ascribed with a capital P is actually just where are the tanks located. And you can see them on the plan you've given us. If you look at the intersection with the public highway and you go southwest, there's a tiny little access road that's been built with two little tanks. In fact, I can't point it out to you other than, but if you look at the inset A and you trace up from the bottom left-hand corner of the inset box, there's a red road, Wellfield Road, that goes up and it turns northwards, and just after it turns northwards, there's a little something coming off it to the right, which isn't marked with any colour, but is a tiny little spur and then a couple of dots. That, as I understand it, is the water tank, the circular water tank and the square water tank disused, shown in the photographs.
Yes.
Right. And that is what is 1,697 feet southwest of the intersection with the main public highway, because if you trace up, as it were, northeast, you come to the intersection with the public highway and Wellfield Road, which is towards the right-hand side of this inset box, just where there are lots of red dots. Yep?
Yes.
Right. So all the judge is doing in paragraph 1 is defining where the storage tanks are, and she designates that as the property. And my understanding of paragraph 151 was that all that the parties were agreeing was that the water holding tanks and storage were on that bit of the property as defined, 1,697 feet southwest of the junction. In other words, it's just saying that's where the water tanks are.
Yes, Lord.
Right. And my understanding of your case is that that bit of land cannot be identified as the land which is conveyed in the 1963 conveyance. Because if you, assuming that's what you're looking at for the good root of title, you don't have to go back any further, just go to that document. You cannot show that those tanks are on the piece of land conveyed in the 1963 conveyance. And the reason for that is twofold. One, it's not properly identified, because it could be any bits of the land, frankly, on this map.
Yes.
And you'll see that if you go back to the will of whoever it was.
William Henry's.
William, and thank you. And then the second is you can't actually trace a personal connection from people. And the judge said that. My understanding is your case is the Court of Appeal should not have interfered with those findings.
Yes.
I understood your case. Whether it's right or
That's
wrong whether it's right or wrong is irrelevant at the moment, but have I at least understood what you're saying?
That's 100% what I was trying to convey.
Right.
Right. And just help me, the paragraphs in the judge's judgment that you say she made these findings which should not have been interfered with are where?
Take you back. #140, which is page 711.
Right.
And she makes the factual finding further, there are no documents submitted which show how the property came to be owned by the late Albert Brennan.
Right.
And then also there's the, and then there's 142, which is on page 712. And it states, reliance on the 1963 conveyance is also questionable as there is no plan attached to describe the property referred to.
No, and just pause there. She can't mean capital P property. That's, again,
Typo.
it's a typo, which we find actually many of that particular typo, because the property referred to can't mean property with a capital P. I mean, it just doesn't make any sense.
Yes.
Right.
And then,
And so her point there, as I understand it, is, and this is where I will need some help from you, for just speaking entirely for myself, when you look at the plan and look to the conveyance and the will that's referred to in the conveyance, I find it very difficult to identify which piece of land is said to have been conveyed, and to relate it to the bit of land on which the water tanks are built. And I think that's your point.
that was always our point from,
Right, but-
from the filing of our defense and throughout the course of the trial, that if you look at the 1963 conveyance in and of itself, it provides no true boundaries to assist you in trying to identify.
There's no map and the description.
And the only reference they give you in terms of boundaries is to refer to the will of William Henry. And even with that, my lords, I'd like to highlight, if you allow me.
So are you now going to take us to the 1963 conveyance to make these points?
Yes.
Good, right, okay.
The 1963 conveyance will be found at page 81.
Yeah.
And in terms of the description of the property, it says land containing 660 acres, more or less being a portion of an 860-acre out of tract of land granted to Joseph Evans between middle and southern Bight, more particularly described in the will of William Henry Sweeting, late. They give the reference for the will. And what I would like to highlight is that, just to put it in perspective, Andros is probably one of the bigger islands we have in the Bahamas. We're made up of a number of islands. And to say something is between 660 acres between middle and southern Bight is like saying 660 acres between Leicester Square and, Piccadilly Circus. It doesn't give you any idea or any comfort as to where exactly that particular property is being said it is. And then the other concern was it makes reference to the Joseph Evans property, but it doesn't, or grant, sorry, but it doesn't give you the reference as to which particular grant it is. In fact, it's only through research that we determined that it's F-28, but this is just to show you the glowing inconsistencies within inside this particular document, and which would have led the trial judge to question and investigate the title.
But as I understand it, what that says is what is conveyed to the purchaser, in other words, to demonstrate the respondent's root of title, is a conveyance of 660 acres out of 860 acres originally granted to Joseph Evans, as more particularly described in the will of William Henry Sweeting. Now, if the will of William Henry Sweeting contained a proper identification of that land, there would be no problem with that route of title, would there?
Yes, my lord, I agree with you. And
So
I
the
would take
question-
you to,
So you've then got to go to the will of William Henry Streeting, haven't you?
which was all a part of the investigative process that we embarked upon, and I'll refer you to page 44.
But isn't that exactly the investigative process that Mr. Ledee was instructed to undertake and did undertake and gave evidence which was not challenged by your
I
client?
think
And that was what-
Well, his evidence was challenged by our witnesses, milady.
Yeah, but
Such as Sanford Coakley and so forth. But what the judge found was that because the survey plan was registered by the Survey General, she accepted it as, on the face of it, a plan of the property.
right. So if we
but-
look at his witness statement at 175, it explains what he was asked to do and what he has done by looking at these different documents, looking at the physical boundary survey, which I don't think we've been given, and looking at the 63 conveyance and the earlier documents. And this is the plan he came up with
Well,
of her property, and that was then ready.
the subtotal of all of his evidence is that he could not rely on any one particular document to identify the property, which we say is why, for the purposes of the common law rule as to root of title, the 1963 document is not a good root of title, because that document in and of itself, even if it's juxtaposed with the will of William Henry Sweeten, which is at page 44, if you look at it, there may be one or two more boundaries contained in that particular document, but it really doesn't take you anywhere in terms of being able to ascertain whether or not, where exactly the true dimensions, boundaries, and shape of the property that's supposed to be conveyed by the 1963
Well, you
conveyance.
presumably put those points to Mr. Ledee, but that was what the evidence was that was accepted.
Could you help me in relation to the will of William Henry Streeting?
Yes.
And he leaves property to his sister, Siva Butler, to his daughter, Phoebe Ann Braynen, and to his son, Arthur Thomas. Okay? So, are we concerned about the land that was given to Arthur Thomas? Is that the land that comes... in order to identify what land was contained in the 1963 conveyance, is that the relevant portion? Or just correct me if I'm wrong. It is.
I understood that the 600, it's confusing because there are two references to 660, but as I understood it, the conveyance conveyed 660 of 860, and the only thing that is 860 mentioned in the will is the
Arthur Thomas.
devised to Arthur Thomas.
Yeah.
So that is said to be the relevant piece of land on which respondents say you can find this water, correct?
Well, funny enough was, if I'm not mistaken, my learned friend inside her written case is making the argument that the property in question is 660 that was willed to Phoebe and Brennan.
Well,
I'm not saying that I agree with that. I'm just saying,
no. Well, this is the confusion I have as to identifying the property, because there's first of all a confusion for it being 660 out of 860, which seems to be what it says, which, as my lord has just referred you to, takes you to Arthur Thomas's bit, not Phoebe Ann Braynen's bit. But in fact, I have another problem with it, which you hopefully can help me with, because the 100 acres that's granted to Sever Butler is said to be adjoining the land granted to Thomas Hodgson on the one side and fronting onto the sea on the other side.
Yes, my lord.
Well, the only bit of land that I can see which adjoins the land granted to Thomas Hodgson on one side, and that's on our plan at the top left-hand corner, and fronting onto the sea, which is the Atlantic Ocean, is, depending on how much 100 or 130 acres is the bit in the top corner, which, if you extend it down, could include the water tanks. So that would be the bit that's granted to Sever Butler. That, by description, that seems to be the relevant bit of land we're all looking at, and that went to Sever Butler. And I understood your case to be, because of these problems, as the judge found, you say, you cannot actually start from the conveyance, go back to the will, and identify the bit of land that those two documents are dealing with.
Yes, my
And
lord.
my understanding is that's your case.
Yes, my lord.
Have I misunderstood it?
Yes, you've correctly identified it again. I mean, it's always been our case that based on these two documents, even if you read them together, it would be different, Lois, if I may, if on this survey plan, let's say, Mr. Leday identified for everybody, this is the portion, 100 acres allotted to Sever Butler. This is the portion, willed to Phoebe Ann Braynen, or allegedly willed to Phoebe Ann Braynen, and then this is the portion that was owned by Arthur Thomas.
He doesn't do that.
But what is that red line that goes across on the map
It's the right.
plan? Is that the upper boundary of the land that he says is conveyed?
No, the bright red line is the road.
That line.
This is Wellfield Road.
The bright red line is well-filled red. My understanding is that, as I said, we identified the bit of where the water tanks are situated. I did that earlier. And it depends how far, because of the description, it seems to be perfectly clear that 100 acres, and we know that that may be an understatement of the actual acreage, because I think there is evidence that old maps generally tended to understate the acreage. It must be the bit that we're looking at to the right of the original grant to Thomas Hodgson and to the left of the Atlantic Ocean. And it could, depending on where 100 or 130 acres takes you to, include where the water tanks are, and that would be the amount granted to the widow. To the sister, Sever Butler widow. So that's one possibility. Another possibility is that it's 660 acres given to Phoebe Ann Braynen, but it's unclear exactly where that is, except it's not clear to me which bit of this plan that is said to be. And then it's also possible that it's 660 acres out of the 860 acres, which is the land, if you look at the description, adjoining the eastern line of the original tract of land granted to John Kemp. And the bit that's granted to John Kemp, you can see on our map, is in the bottom right-hand corner, because if you turn your head sideways, you can see original Crown grant to John Kemp. And there's a line, and that is a long way away from where the water tanks are. And my understanding is you're saying this was the uncertainty, or one of the uncertainties that the judge identified, because there is no plan attached to the conveyance.
Yes.
Have I understood
Yes.
it accurately? So, just to finish my thoughts, and then I will shut up, I promise. The last paragraph of the judgment,
Just before we get there, I want to follow precisely what's being said. If one looks at the 1963 conveyance, page 81, and we've seen the reference to, more particularly described in the will of William Henry Sweeting, and so on, which the will is recorded in book R8 at pages 418 to 424. Can I just confirm that what we were looking at on page 44 is the will as recorded in book R8? Is that right?
Yes, my lord.
Okay.
I find it easier to read it at page 1059. They've actually got a type there.
Right.
It's absolutely appalling.
My Lord's assisting me. 1059.
Right.
I think we've got a. We've got a typed up version. Is that right of the will?
Paragraph
Yeah,
57.
it's even better at 1012 in the Statement of Agreed Facts and Issues.
We transcribed it so that it's more legible.
Yeah. But, so there were 3 bequests, 860 acres to his son, 660 acres to Phoebe Ann Braynen, and 100 acres to the sister Sever Butler. Now, the conveyance says it's 660 acres out of the 860 referred to in that will.
Yes, my lord.
And therefore, at least as I understand it, the root of title says you've got to identify as 660 acres out of the 860 acres granted to Arthur Thomas. And the Arthur Thomas bit of land, as the middle description in the will says, it's 860 acres to adjoin the eastern line of the tract and the land granted to John Kemp. Well, as I understand it, if you look at the plan, the land granted to John Kemp is the land to the right of the vertical line. I mean, if you can see that down the coastline there's an expression Mangrove Cay settlement, just below the words the Atlantic Ocean. So just below the words the Atlantic Ocean it says Mangrove Cay settlement, and there's a vertical line that runs down the page. And to the right of that vertical line, you can see the sideways writing, original Crown Grant to John Kemp. So that the bit of the 860 acres...
Sorry, doesn't that say other portion?
Original
Crown Grant to
Is that original?
John Kemp.
Which one's that then?
Well, no, the big vertical, I mean, all the stuff to the right of that vertical line is John Kemp, one way or another, whether originally or other, because it's the big capital letters that are printed sideways on the plan.
Original.
Yeah, and therefore, if you look at the description, as I understand it, the 860 is most likely to be the bit immediately to the left of that vertical line, which the plan says other portion of original Crown Grant to Joseph Evans, and in very small print you can see total area is 1,100 and something acres. And I thought the evidence was that actually that was the 860 acres, because there was evidence that the actual acreage, as now measured, is greater. But that does not include where the tank is. And so, as a documentary title, it doesn't connect on the plan. And that's what my understanding of what the judge was saying.
And indeed, my understanding as well was that if you have 660 acres, more or less, being a portion of 860 acres, you haven't the faintest idea what the portion is or where it is.
And that was the greatest difficulty there that we had raised before the court, the trial judge, and she had the benefit of hearing this evidence and testing it and asking questions herself. I mean,
But there appears to me to be no answer to those points at the moment.
No.
And
Respectfully, we submit that there are no answers. And so we say that based on these factors, that well, first of all, there's the conveyancing document. We say that based on the common law, the judge properly should have gone and investigated the title. In looking at the title, it was discovered that there was, of course, a Joseph Crown Grant.
But just to be clear, the judge didn't need to go back beyond the 1963 conveyance. The simple question is, if that was a conveyance of an identifiable piece of land on which the relevant structures are built, there would be a presumption that that was a valid conveyance.
Yes, my lord.
So she didn't need to go back any further than that. That's as far as she needed to go. But the question is, does that identify the land properly?
Well, respectfully, we still maintain it based on the definition, the common law definition. It's twofold in that if the property is not properly identified, it's not a good root of title.
Yeah.
But because it's a presumption on the face of the conveyance, it's a rebuttable presumption, and if she was presented with facts that go back past the 1963 conveyance, properly she ought to consider that evidence in determining whether or not there is a good root of title. And we say on the face of the conveyance itself, there was a number of discrepancies, as we've already canvassed for the most part, that would have raised alarm bells, whereby she would have had to consider the Joseph Evans Crown Grant and also the will. And in so doing, a property inside the Bahamas, just as a little segue and way of background, because we don't have a land registry, normally what we'd have to do is pay a particular company. There's only one real reputable company in the Bahamas that I'm aware of, and that's CompuTitle. They would do a title search as to determine whether or not there's any documents relating to this particular piece of property or relating to these individuals.
And they did that.
And we did that, yes.
And nobody else is claiming this land. Your client was not saying that they had thought someone else had owned it, or that they'd got permission or sought permission from anybody else who...
Well, our client has always maintained the position that either
They don't
the
claim
descendant...
they ever bought it from someone, did they? Or leased it, or have a license from someone to use it?
Our client says that Joseph Evans and his descendants are the true owners of that tract of land, or alternatively, although we didn't discover any documents how William Henry Sweeting would have come into possession, but by his will, there's the argument that him and his descendants were the true owners of the property. So we offered...
Where are they?
Pardon?
Where are they?
Nobody knows. Nobody knows how to identify them or trace them. I mean, if you look at the date of the...
Was this part of your pleaded case?
Inside our pleaded case, we do speak to, if I can take you to it.
Sorry,
Sorry.
I'm now getting confused. Just before we do that, can we just make sure what the Court of Appeal thought it was doing? Because although reference has been made by my lords to paragraph 151, in fact, looking at the Court of Appeal's judgment, they think that the relevant paragraph is 152 in the judge's judgment. Paragraph 152 in the judge's judgment, she says, considering the evidence before me, I find that the property claimed by the plaintiff is that on which the water holding tanks and storage are situated. And looking at paragraph 38 in the Court of Appeal's judgment, page 906, we see that in the Court of Appeal, the appellant drew attention to that finding of fact, and the Court of Appeal says, since the respondent has not cross-appealed in relation to that, those findings supportive of the appellant's claim are now final findings. So, I'm sure it's my fault, but I was reading both the judgment and the Court of Appeal's interpretation of the judgment as being based upon the finding of fact at the end of paragraph 152.
Yeah, except just if you turn the page and read 153, the judge says that the survey being registered doesn't prove that the plaintiff, capital P, owned the property.
Yeah, but that's, she's made her finding of fact at 152. I'm not sure what that's got to do with that. So, well, assist me. I mean, that's how I had read both the judgment and the Court of Appeal.
That she was simply summarizing the position held by then claimant is now responding, Carla Braynen Turnquest, namely that they are asserting the property claim by the property, as in basically she's asserting what they're claiming, but as I indicated earlier, it goes in our challenge that we couldn't identify the property, that the water tanks were actually on their property.
She says, I find that the
Yeah,
property-
and she's not summarising someone's case. She's very specifically making a finding on the evidence before her.
It was from Mr. Ledee.
But is there an ultimate conclusion? I mean, even though that said, it's our ultimate conclusion that, based on the documents before her, you could not identify the actual property that's said to be owned by the respondent.
All right.
And
Sorry, so you were going to take us to your pleaded case, I think, in answer to my lord's question.
Yes. If I take you to page 25, paragraph 10.
Page 25, did you say?
Yes. Paragraph 10. And this particular paragraph, Lois, also goes to your point, to your point, Lord Snowden, that you had raised earlier. We say the defendant avers that the plaintiff has no documentary title whatsoever. The plaintiff does not have possessory title, and the plaintiff cannot positively identify that the property occupied by the defendant is the property allegedly conveyed to Carla Braynen and from Loretta Braynen. With that said, we go on, and this is to answer your query, Lady Rose. On a 65,000, well, on the square footage tract of land, the defendant's possession and usage of 15,192 square feet may actually be located on land owned by Arthur Thomas Sweeting, which is 860 acres.
So, sorry, where are you reading? Oh, right at the end.
Paragraph 10.
Right,
Yes.
but that's not a positive case. You were suggesting you had a positive case. You don't.
We're saying two things in terms of the ownership of the land. We're saying in this instance that it would be, the land would be owned by the descendants of William Henry Sweeting. We also, in our written case, spoke to the fact that it may be owned by the descendants of Joseph Evans, the original grantee. And then alternatively to all of this, in our pleaded case, we speak to the fact that we've put our possessory title, and we're asserting our possessory title, in that we've been in undisturbed possession of the property. In the pleadings, we say for at least 34 years.
But that's a different point. But if it's owned by one of these descendants of these other people, what right have you got to be there? Apart from, I mean, what right did you have to go in and build your water tanks there?
We took adverse possession. We didn't have a...
You didn't have adverse possession immediately you went in and built the...
No.
So on what basis did you occupy that land? You're not saying that any of these descendants have given you the right to go into the land?
No, and given the history of this particular corporation, because it's changed hands so many times through successive governments, we wouldn't have been able to obtain that sort of information in any event. We wouldn't be able to lead evidence on it, and therefore we didn't plead it. For the purposes of this particular matter, all we wanted to do for in terms of the trial, is, as it was competing titles claim, we were simply just trying to demonstrate to the court that our title, we proved, and I stress the word proved, that our title would be superior to theirs, the respondents, given all the circumstances, because first and foremost, they don't have a good root of title, so there's no real challenge to our possession of the property. But in any event,
Sorry, could I just pause? You're being sued for trespass. You don't say you went onto the land with any right granted to you by the owner or anybody else. You accept you went onto the land at the start as a trespasser.
yes,
Your case is, it's just that the person who would be entitled to sue you for trespass is not the claimant, because the claimant can't establish a better title than can't establish any title, in mind a better title, but any title, documentary or otherwise. You would accept that you could have been sued for trespass by the true owner or somebody with a better title to you at the start, but you just say it's not the claimant,
yes,
the plaintiff. You then say, in fact, as against whoever owns the land we acquired title by adverse possession, because we'll come on to that, and you say once you had acquired title by adverse possession, that's an end of it.
yes,
That's my understanding of your case. So the answer is, you aren't ever claiming that you went onto the land with anybody's true legal permission. It's just that you say this isn't the person who could sue you for trespass.
that's correct, Lord. Yes, my lord.
Why didn't you appeal against the findings of fact? But page 906, paragraphs 38 and 39 of the Court of Appeal's judgment. You're raising a point now.
Sorry, my lords.
There's finality in litigation. You can't have not appeal something to the Court of Appeal and come along here and raise the same issue again.
And your question is whether we raise these issues inside our appeal itself, or?
Well, you were the respondent in the Court of Appeal. You hadn't cross-appealed against the finding of fact in paragraph 152 of the first instance judgment. And that is, I find that the property claimed by the plaintiff is that on which the water holding tanks are storage are situated.
With regards to that, I think it goes back to the...
And just to note, that's not using property capitalised. It's being very specific. And also, just to make the point I believe my lord is making, if one turns to the Court of Appeal, the Court of Appeal implies its own definition of property in paragraph 1, and it's that definition which is being referred to in paragraph 38.1, based on their interpretation of paragraph 152 of the judgment. In other words, that the water holding tank and storage apparatus is on the very particular property being claimed by the respondent in this case. So that seems to be a finding of fact. And I think it's being put to you, how can you go behind that finding of fact at this level?
Because, well, I think the the fact of the matter remains that the learned judge, despite that which they're relying on, has maintained and relied on the fact that it's uncertain based on the 1963 conveyance. Although she may have made reference to that at that particular paragraph, ultimately when you read her judgment as a whole, throughout is replete with the fact that there was no plan and no way to identify whether or not we're on that, but I mean, whether or not that property in question is truly owned by the respondent. And that's the true question or test that we were dealing with.
Sorry, can I just pick up my Lord's question to you? The use in paragraph 38(1), there's a reference to property capital P, and it's defined in paragraph 1 as simply being land situated in Mango Cay on the island of Andros, the Bahamas. Doesn't.
Well, it's the claim in trespass in respect of that land. We know what the trespass is about. It's about the positioning of the water tower and storage facilities. Well, you've got quite a lot of ground to cover, so I mean, you must take your own course as to how long you want to spend on this point.
Well, I mean, we say that the argument as it relates to no good title, root of title, is essential to our case, because if this honorable court finds, or panel, board finds that the learned judge had applied the correct test, which we say she did, and relied on the evidence which she relied on, her judgment shouldn't have been interfered with by the Court of Appeal. So this is central, and we say if it's deemed, of course, that the property is uncertain based on the 1963 document, then that's the end of the matter. Alternatively, if it is deemed that, alternatively or in addition to, if it's deemed that looking at the history of the documentary title, it cannot be proven or shown how Mr. Albert Braynen came into ownership of the property, which is a fatal flaw to their claim to documentary title. We say that that in and of itself, or combined with the uncertainty of property, would bring the matter to an end, because we would say that they have no documentary root of title. Good documentary root of title, I should say. I mean, it's all fair and well for them to write that they own this property on a piece of paper, but how do you convey something that you have no interest or estate in? And that's the thrust of it here.
Yes.
With respect to the judgment of the learned trial judge, the reason why we didn't cross appeal is because we say that she got it right. She addressed her mind to whether or not the property was identifiable based on the evidence before her, namely that Mr. Ledet had to rely on so many other documents, and the boundaries inside the conveyance itself, as well as in the will, didn't really take us anywhere. If anything, it confused the matter a lot more. We say that she was perfectly within her right to say that the property was not readily identifiable, even though, and this is her finding.
Well, I've just done a quick word search for the name Sweeting in the submissions transcript of the Court of Appeal, and I can't find it at all. Was any argument raised in the Court of Appeal that the 1963 conveyance, you've got to go then to the will of William Henry Sweeting, and you don't know where any of this land is? Was any argument raised about that?
About where the land was in connection?
Yeah, that's right.
I'm not certain if any argument was raised about it then, but it was always our position and issue that even when you juxtapose the two of the documents together, you cannot identify the boundaries, especially without the benefit of the plan. You couldn't identify the boundaries relying on those two documents. And that was actually the evidence of Mr. Ledet. He was specifically cross-examined on that information, and he specifically stated that he could not identify the property in question based on any one of those documents.
You got a reference for that?
Yes. I could take you to page 284. Paragraph 5, and this is the witness, Mr. Emile Ledet. So all of references that I use to execute the survey would be
Is this a transcript of the Supreme Court or the Court of Appeal?
Supreme Court.
Right. Well, I was more...
And this is the cross-examination of Mr. Emile Ledet. Or, sorry, the re-examination, I think. And it says, so all of the references that I used...
Sorry, this is re-examination, you're saying?
Yes, yes.
Right, okay.
To use, that I used to execute the survey would be all of these documents would be in that file in the Department of Labor. So all of those documents that you relied on are on the survey itself, yes.
And what's being referred to, P19 of 2011, what's that?
I'm not sure what that reference is, but I can tell you, Lords, Emily, that if we had to look at this, the actual survey plan,
I thought you were assisting us with a reference.
that is the reference to say
Mr.
that
Ledet says he couldn't identify the property.
that's in order to conduct the survey plan and to identify the property. I mean, there's a number of paragraphs throughout dealing with this particular point. I don't know if you want me to take you.
Well, I want to understand why you've taken us to this.
This is to
page
say
in the
that
transcript.
in order for him to complete the survey plan, in order for him to identify the party, this is just one of the quotes that I rely on to say that he, in order to do this, he says that he couldn't rely on just the will or just the conveyance.
But
He had to rely on.
he's not saying that here, that I can see.
I'll take you to.
Are the will and the conveyance in P19 of 2011?
I think this is the survey plan that he's referring to. But if,
So P19 of 2011 is the survey plan itself, is that right?
yes,
Which is this large
plan,
plan we've got. And
And-
he's saying the references I used to execute the survey would be all of these documents would be in that file in the Department of Lands and Survey. So what are the documents in the Department of Lands and Survey? And that'll include the 1963 conveyance and the Sweeting will, won't it?
well, that's the other point, my lord. Right?
Well, can you answer me first? Does it at least include those two documents?
It does not include the will, my lord, we'll say that. And the ledger doesn't speak to the conveyance either. It just goes on to state all the different plans. And in fact, there's evidence before the court below, during cross-examination where my learned friend spoke to the fact that the will was not a document that made up the reference for the plan. And in fact, it was the appellant, Water and Sewage, that produced the will for the court's benefit.
Is the answer to my Lord's question, in fact, not 284, but you need to look at electronic bundle 290 to 291? Because that's where this witness was asked about what he got from the conveyance and what he got from the will. And he said he couldn't identify where the 660 acres is based on the conveyance, and he said he couldn't map out with any degree of certainty where the 660 acres is based on the will. And he said, no one could do that. I mean, that's 290 to 291. Isn't that the answer to the question that you were asked?
Yes.
I mean, I'm not sure why you took us to 284.
And which part of the examination of this witness is at page 290 to 291?
That's cross-examination.
That's cross-examination.
That part is
So you told us the earlier bit was re-examination. Why was he being cross-examined after re-examination?
No.
You told us that at page 284 he was being re-examined. Anyway, you say this is cross-examination, is that right?
That's right. I identified as re-examination because I saw Mrs. Roll.
And that's helpful.
Yes.
Could we go back to my Lord Stephen's question, which related to the arguments that were presented to the Court of Appeal about this? And I think my Lord was saying that he could not detect any reference to arguments based on what could or could not be discerned from the Sweeting will in the Court of Appeal.
I've done a word search for the word sweeting and also a word search for boundaries, and I've come up with nothing so far. And I'm not saying it's under pressure of time, so I haven't, if there's anything, is there any part of the submissions made to the Court of Appeal that raise the point that the High Court judge, the Supreme Court, was incorrect, patently incorrect, in finding that the water towers were on land to which the appellant had title?
So when you say respond, do you mean your client's skeleton argument? Yes. Yes, all right.
And if we go to paragraph 11, it says, further, if Albert Braynen did somehow, some way, mysteriously have such title to the property, we submit that there is no document, not the will of William Henry Sweeting, and not 1963 conveyance, that accurately describes the property, and there is no plan attached to any of the documents that assist.
And was that then developed in argument?
And I think my Lord's question specifically was, did you argue that the the Supreme Court had been wrong to find, in paragraph 152 as we were looking at, that the towers were on land to which our appellant had title? Is that argument set out in this document?
I don't think there is that specific argument run in before the Court of Appeal, because we concentrated on the fact that the trial judge's ultimate finding, despite that one little paragraph, if you look throughout the body of her judgment, we found favor with what her findings, in that you could not identify the property through the use of the conveyance or the William Sweeting will, William Henry Sweeting will. And so that was the thrust. And
just make sure that I completely understand that there were no submissions made to the Court of Appeal that if you look at the parcel clause and combine it with the will of William Henry Sweeting, you cannot identify the land which was the subject of the 1963 conveyance.
Just so can you repeat the question, just so I...
But you've taken us to page 777 and paragraph 11, okay? And I want to see whether or not an argument was raised before the Court of Appeal that if you combine the parcel clause with the will of Sweeting, it is impossible for the plaintiff to establish ownership of this particular piece of land.
That was also, yes, sorry. I just wanted to make sure. But that was also part of our written case as well.
It was
that we raised.
It was part of your written case.
Yes.
Right.
And we raised it in paragraphs 33,
I was-
oh, sorry, page 784.
Sorry, 784.
Page?
784 is what
Yeah,
he
784.
says.
784.
Yes.
And we're looking at paragraphs 33, 34, 35, and 36. So it says, to further complicate the matter, Crown Grant F28 refers to 1,500 acres and not 860 acres. How do you identify 660 or the 860 from the 1,500 acres? How are we sure that on a balance of probability the conveyance pertains to the Crown Grant F28? It was for the appellant to prove, not the respondent, and the appellant failed to prove anything. The conveyance goes on to say between middle and southern bight, more particularly described in the will of Henry Sweeting, is our respectful submission that in examining the will of William Henry Sweeting, no boundaries or dimensions are given in connection with any 660-acre tract of land. Further, there is no plan or map attached. In other words, the will lends no assistance in and of itself to the description of the property in the 1963 conveyance. Further, the Sweeting will speaks about 860 acres given to Arthur, 100 acres given to Butler, and 660 acres given to Phoebe Ann Brennan. It should be seen as a major issue that F20 spoke to 1,500 acres. William Henry Sweeting, who allegedly bought a portion of the property from Joseph Evans, is referring to will 1,620 acres. This is a major discrepancy. Further, we do not know what the conveyance or deed conveying the property from Joseph Evans to William Henry Sweeting actually conveyed or stated, if one actually exists, which is doubted.
Yes, thank you. Now, I am a little bit concerned about your use of time, because you've got until 12:30. So I think we need to move on to some of the other points that arise, so that you have an opportunity to deal with those.
Yes, Lord.
Unless you wanted to take more time.
Oh, no, Lord. I mean, I think we made our position clear. That is the true, just for the sake of clarity, it's a two-pronged attack. We say that...
Can I just ask one question? So sorry to cut you off like that. Do we have your notice of appeal to the Court of Appeal?
He's the respondent.
My written submissions to the Court of Appeal?
He was the respondent.
Oh, I'm so sorry. Yes, you're the respondent. Yes, and you didn't have a respondent's notice. No, right. I understand. Yes, thank you.
Yes, Lord.
You were just summarising. You had two limbs to your case.
So we say that the judge got it right in her finding of, based on the law and fact, and the test provided under the common law for a good root of title, that there is no document that says how Albert Brennan came into possession. And on this point, I'd like to raise the fact that there was no answer from the respondent on this issue. They could not produce a document that demonstrated how he came into possession, and in fact it was conceded that there is no document that shows how he came into possession. That was during the evidence of the respondent herself. And it's just factually correct, as you can see from the reproduced record. It's funny because the Court of Appeal and also my learned friend say that the Conveyancing and Law Property Act does not apply. In particular, Section 3.4 of the Conveyancing and Law Property Act, because it deals with vendor-purchaser. We tend to agree with that position. However, that position is, that particular section is relied upon to say that properly the trial judge should not have gone behind the 1963 conveyance, given the lapse in time that, that when that document was created. We say that that fiction is created by a statute, which is and it only was created for the benefit of a vendor conveyancer, vendor purchaser situation, which is not the case here. We're dealing with a competing title trespasser, adverse possession action. So properly, the court had every right based on the common law. But even if, let's say, this, based on common law, to investigate the title or look behind, especially once she looked on the face of the conveyance and saw a number of discrepancies, namely that the Crown grant didn't give a reference, the description was defective, and also the boundaries were allegedly set out in a separate document, which was the will. And bear in mind, there's no other document referred to in the will or the 1963 conveyance that purports to help with the boundaries or has a plan attached that she could refer to. But in any event, with regards to Section 3.4 of the Conveyancing Law Property Act, the case law makes it clear as well that that's only a presumption, and so long as there's some reasonable doubt or the presumption has been rebutted, we say is the obligation on the behalf of the trial judge to investigate and go past that particular period of time. And that's what she did. And so therefore, there's no answer, we say, in respect of, number one, the certainty of the property or lack of, or number two, the failure to reduce, the inability to prove to the court on a balance of probability how Mr. Albert Braynen came into ownership of the property. The last point, and we say if the court finds favor with any of those arguments, that's the end of the matter, because we are...
So can I just check? Yeah. You said, I think, that you tended to agree that Section 3.4 of the Conveyancing Law and Property Act did not apply.
Does not apply.
So I just want to make sure that you're accepting that the judge has gone wrong at paragraph 143 of her judgment, where she seems to examine that.
I think the point is she had to make reference to Section 3.4 because my learned friend, the respondent, had made reference to Section 3.4 and the fact that there was no need for the full investigation of title, and that the judge should not have gone behind the 1963 conveyance.
All right.
And so therefore she had to address her mind to that particular point. And she felt as though, and that's how she came to that conclusion.
But you accept, okay, you accept that the judge wrongly referred to Section 3.4 of the conveyancing statute because this wasn't a vendor and purchaser situation. But my understanding is you say the judge was right to look at the common law position. And when she did look at the common law position, which you showed us the quote for, as I understand it, you say she found that there was, as I understand it, the finding you rely on is the one at paragraph 148. I do not find the plaintiff is the owner of the property by documentary title, and the 1963 conveyance provides no proof of ownership of the property in the dispute, as it is not a good root of title.
Yes,
So that, okay.
that's ultimately her finding.
And then we've got the paragraphs which follow it, which say well, something or something else.
Yes.
Anyway, but my understanding is that we can put section 3.4 to one side, but you want us to concentrate on the common law the approach that the judge adopted and the findings that she made.
Yes, and she specifically said so at 147, as I had indicated before, the common law position is, and specifically drew her mind and made her findings on that basis, namely that there was no good root of title. And there was, like, as I indicated, the only real reason why I think she did make reference to the section 3.4 of the Conveyancing Law of Property Act was simply because it was raised by my learned friend, and to this day I think it's still being relied upon to some extent by the Court of Appeal and also by my learned friend to say we should not go behind the 1963 conveyance. But we say in the interest of justice, if the court is committed with the evidence to demonstrate that there is a fundamental defect in the conveyance whereby it demonstrates that there is no good root of title, this should not be ignored.
Yes, thank you.
And then just quickly to move on, Lords, we say that separate and apart from that, worst case scenario, if my lords do not find favor with that particular argument, the learned judge did find that we had possessory title that would be superior to the respondent, in that we had obviously physical possession of land. Of course, it's questioned as if we are on their actual land, but the fact of the matter is we have physical possession of land. If you look at the pictures, just to quickly, I don't know if, but just to quickly have a look at them, page 38, 39, and 40. And you can see the size, sheer size of it. And there's evidence led before the trial judge that those water tanks actually provide water for the inhabitants of Mangrove Key. And so we respectfully say it was perfectly within reason for her to determine that, number one, we had factual possession. You'll see the gate, the fences around those tanks. Those tanks are to provide water to the inhabitants. And an intention.
So page 39, what is that? It seems to be something else which doesn't have a fence around it.
Looks to me like an older version of a water tank.
Yes.
Yeah.
I think that was an older tank. These are the more modern ones, the round ones.
Right.
I mean, my understanding is that the circular water tank is on one side of the little tiny road that's being constructed to the south of it, and the square thing is to the north of it.
Yes.
So where we have two pictures of a circular water tank, they're just taken, it's one water tank taken from a different direction, is that right?
Yes. And what we say to that is there was obvious intention to possess the land because, number one, just by the sheer size of these facilities, you're not going to build a water tank with the view to simply tear it down at a later stage if somebody says, just willy-nilly. It holds a function for the community.
When was the new one built?
Well, all of them, there was no definitive evidence as to when that new facility was built, but the evidence before the court is that she accepted, all of these are within the same vicinity, all said to, alleged to be on the respondent's property. And the evidence that was accepted, it was in the agreed bundle, was the 1983 memorandum that makes reference to the water tank facilities. The fact that they're,
But I mean, that's probably referring to the old one, isn't it?
But-
Page 39.
we're saying that they're all relatively in the same space.
Right, well, they're in the same space, but we're asking about timing, because the new ones
But,
appear to look very new.
yes, but the fact of the matter, as a whole,
Are we assisted at all by anything in the evidence or any finding by the judge as to when the new one was
no,
put in?
Lord. And these, but the fact of the matter is that
And is that because you didn't lead evidence about when the new one was put in?
No, we didn't need any evidence as to when the new one was put in.
Or as to when the fence.
The only thing that I
Just do apologise. As to when the fence was erected, as to whether there was any lock on the fence.
no, Lord.
Whether there was any sign up saying, "Don't intrude."
No, Lord. We didn't need any, to be honest with you, I'm very candid. There's no evidence led to that extent. The only thing that I would say is that with respect to the water tanks in question, there is the evidence of Cyprian Gibson, who is the employee of Water and Sewage. He gave evidence, and it was his evidence in his witness statement and also during cross-examination that the tanks in question, he didn't specify old or new, but we would assume that we say that it would be within the realm of probability and accepted by the judge that for the period that he's been employed with Water and Sewage, and I'll get the exact dates for you in a second.
Well, I think since we're interested in this, if we could have three references. One is to Mr. Gibson's witness statement, second is to anything relevant in his cross-examination, and the third is to what the judge found in relation to the evidence he gave.
Okay, with regards to his witness statement, is that it may be found on page 189.
Thank you.
And the relevant portion of his paragraph 2 says, "I'm the family island manager of the defendant, which is Water and Sewage, having been employed with the defendant for 25 years, and I currently hold the position of assistant general manager of Family Islands," which demonstrates that he's very familiar with this particular watering station. And if we go to paragraph 4, he says, "The well field and the water distribution system has been maintained by the defendant since at least 1983, as evidenced by the document at tab number 14, which is the 1983 memorandum that I was speaking of." And he says, "The defendant has maintained and has enjoyed uninterrupted possession of this property for as long," and the key words are, "as long as I have been employed with the defendant." Now, if we go, if we count back 25
So
years.
he doesn't talk about anything about what the intention was.
As it relates to the use of the water tank? What?
As to the intention to exclude others, including the owner with paper title.
He does not speak to that, Lord. However, it's our respectful submission that is based on the facts before the case. By looking at the pictures themselves, it demonstrates that they have an intention to exclude all others.
Well, is that what the water company, seriously, you're saying that's what the water company does? It finds a patch of land which it knows it doesn't own, it builds a water tank on it, and just sits there intending to acquire property by adverse possession?
I think
Do all the
in this
utilities
instance,
behave-
I mean, I can't speak to them, but I can only offer this, milady. I would say that the intention is for them to ensure that these smaller, more rural communities have access to water. In a lot of these instances, they don't know who the true owners are of that particular piece of property. So what they would do is they would go on the property as needed for that particular settlement. It's not, say, like Nassau, which is heavily populated, and, you know, you could ask questions, who owns this and who owns that? Or the lots and the property itself is readily identifiable. So in instances on the less popular islands, if they identify the need for a water tank or a power station or something along those lines, government will go on that property, build a facility with the intention to possess. In other words, they don't have the intention to tear it down or move it or
No,
relocate
but
it.
that's not the question. The question is, do they intend to become owners of the land?
Well, we would respectfully submit, based on the case law, milady, that there is no obligation to have the intention to own the property. There's the intention to possess. And if you would like, I could...
Well, it's intention to possess to the exclusion of others.
Yes.
And you're correct, it's not the intention to own, but it's the intention to possess to the exclusion of others.
Yes, ma'am.
And you're being asked whether or not a public body in the Bahamas had formed that intention to possess to the exclusion of all other persons, including the paper owner.
And we respectfully submit, yes, my lord.
It had formed that. And where's the evidence of it?
There is no specific reference to evidence there. The only evidence we have to offer is the fact that, number one, is a large facility. Number two, they gated it. Number three, it's there to provide water to the inhabitants. So in other words, you know, I don't think it would be easily inferred that they would be minded to relocate or have any intention of moving that particular facility if challenged. At best, they may compensate the true owner for that property. That may be the policy, to compensate the true owner if necessary, but definitely is not to relocate or move or and so that's why we say it's an intention.
They had, if the true owner came along at all material times, they would have had an intention to compensate them. Is that right?
Possibly.
But that's yeah. Anyway.
But again, we say that
Well, I think we should make the point. That would be inconsistent with an intention to possess to the exclusion of others. Because if the intention would have been to compensate the owner, well, that's acknowledging that the proper owner has a better title to the property and is not being excluded because a sum is being paid in compensation.
Respectfully, if I could take my lords to the Eleuthera case, just to assist me with the authority.
Yes, I'm a little bit concerned that we don't lose complete focus. I had asked you for 3 references. You've given us 1. Was there anything you wanted to show us in the cross-examination of Mr. Gibson?
Just so I apologize, but I just wanted to take you, just to make the point.
Oh, all right, yes, if it's more convenient for you to
Eleuthera
answer
case.
another question.
In that particular case, oh, sorry, not Pi, not the Eleuthera case, sorry, it's Pi, sorry, which I know is a well-known case. I apologize.
Yes, all right.
One 416.
And if we're going to go 1417,
Yes.
and it states in a number of cases, such as the present case, supporters have given evidence that if they had been asked by the paper owner to pay for their occupation of the disputed land or to take a lease, they would have been prepared to do so. In Oceans Estates Limited, the plot more difficult, given the advice of the Privy Council said that an admission by a squatter to that effect, which any candidate squatter hoping to, in due course to acquire a possessory title would be almost bound to make, did not indicate an absence of intention to possess.
Right.
And they go on to say, a few sentences down, the decision in Pender is to be preferred because it is consistent with principle. Once it is accepted that the necessary intent is an intent to possess, not to own, an intention to exclude the paper owner only so far as is reasonably possible, there is no inconsistency between a squatter being willing to pay the paper owner if asked and his being in the meantime in possession. An admission of title by the squatter is not inconsistent with the squatter being in possession in the meantime. And so we rely on that authority, in other words, to demonstrate that although we're not saying definitively that they were of the mindset that they would be prepared to pay, we're saying that even if they were prepared to pay, this would not take away from the fact that they intended to possess and they intended to remain there to the exclusion of the true paper owner.
Yes.
And, oh, sorry.
Yes, you go on.
And the only other point I wanted to take the courts to, the board to, my lord, while we're at this particular case, is page 1415, paragraph 41. Oh, sorry about that. Can I turn to page 1414? 1414, sorry.
Yes.
And it's paragraph 40, and it's at the very bottom, last part. But in any event, this would be H, sorry. But in any event, there has always, both in Roman law and in common law, been a requirement to show an intention to possess in addition to objective acts of physical possession. Such intention may be, and frequently is, deduced from the physical acts themselves. So I want to speak to that particular as authority for the fact that by our very use of that property, the facility that's been built on it, and the usefulness of the purpose that it serves, we submit that that in and of itself has been recognized by the law as property intention may be reduced from the actual physical act.
Yes.
And then,
Just to remind you, I had asked you if you wanted to give us any reference to Mr. Gibson's evidence in cross-examination, which might bear upon the intention to possess. And I had asked if there was anything in the judge's judgment where she deals with that. But I'm anxious that you don't take up time. If you don't have references that you want to show us, then let's move on.
I'll move on. So we say, again, also, based on the material that was before the court, the evidence that was before the court, there was sufficient, and also the application of the law, the judge was correct to determine ultimately that, number one, the appellant was in factual possession of land, and then number two, that the appellant, had the intention to possess that land.
It didn't attempt to exclude anybody from using the road.
No, my lords. We have no evidence of that, I should say. And no evidence was led on that. I would say in terms of cross-examination of our only witness, number one, no questions were put to him as to whether there was another tank on the island as it relates to his evidence that the 1983 document refers to the property, the facilities that we are relying on. There was no cross-examination on whether or not there was an intention to dispossess the world, so he wasn't cross-examined on that. There was no evidence led as to whether there was another tank on the island, so that the 1983 memorandum may be referencing another tank somewhere else located or at some other point. There's his evidence that he is aware of these tanks and that those tanks have been there for as long as he's been employed, which would have been since 1995. And we say that definitely our usage continues. That's undisputed. We remain on the premises. The facility is still being used for what their intention was, and so therefore we say we've long since passed the statutory period as required by Section 16(1) of our Limitation Act, and we say that that also gives us better title, possessory title, than the respondent. Just a few cleanup issues, lords and my lady. In my learned friend's submissions, she makes reference to the fact that we didn't impeach the conveyance itself, and that we should have challenged it, that we didn't allege fraud or duress or any of those. And our simple answer to that is...
Mr. Rogers, let me just say, you've got 30 minutes set aside for your reply. If you want to eat into that time so that you don't feel under pressure of time now, you're free to do so, just so that you know.
Much obliged. I only have two quick more.
All right.
Hopefully quick points. But just while I'm on that train of thought, we say that there is no case law presented to this court that deals with the fact that properly we should have, that would prove or demonstrate that we did not impeach the 1963 conveyance. The correspondence from Meridian Law Chambers prior to the filing of our defense and our defense itself speaks to the fact that the title is wholly defective. The purpose of pleadings is for my learned friend to be on notice as to what case she has to present and what defense she has to meet. And our defense is very clear on its face that we say that her title is defective, we have superior title, we have possessory title. The 1963 conveyance is not a good root of title because it can identify the property, and also it she has no proof or has not presented any proof as to how Albert Brennan came into possession such that her client would then come into ownership of the property. So we say that that's just simply a red herring. Another point that we wanted to raise was reference was made to Section 38 of the Limitation Act. In my learned friend's submissions, she makes the point that the Court of Appeal did not rely on that as a basis for their ruling. However, we say that because they...
Was the old tank abandoned when the new tank was put in place?
We do not know if it was abandoned or if it was still being used. That question never arose, and we didn't lead any evidence, and no cross-examination was led on it.
So what land is it that you're actually looking at the pictures, 38, 39? What land is it you actually say you now own?
Do you have a map?
You own the circle on the ground underneath the...
We would say, that we, looking at the plan itself,
No, I'm not looking at the plan, I'm looking at the photograph.
well, we would say that we're the owners of all that property which we have control over, and whether we're still in use of using the tank or not using the tank, we are in control of the property at 39 and the property at 40, my lady.
How can you be in control of the square, what appears to be rusty, disused tank, if you don't exclude people from the road to it and you haven't fenced it?
While there's no fence to it, my lord, you'll see from the picture itself, there's no other objects or any other use on that property. So we may not have a fence around it to stop people from actually coming onto it, but there's no evidence led before the court that anybody else has use of that particular piece of property.
I understood that you had been making a claim for 15,192 square feet, and I don't know where they are. I mean, when I said your criticism of the 1963 conveyance is there's no plan attached to it, and I was saying, is there a plan where one can make an order saying this is the area of land which is now belongs to your client?
With respect to that, my lord, we say that we never made a counterclaim seeking a declaration to that extent. All we were seeking to do was meet the claim that was presented to us, namely that we have a better title to the property that our tanks are physically on, as it relates to the respondent in this particular
But
case.
if you establish a title by adverse possession,
Yes,
then that's a title good against all the world, apart from potentially somebody coming in later.
yes,
To it. And I just wonder what area, sorry, my lady asked, what area do you claim title to by adverse possession? And as yet I'm struggling to get an answer.
with that, yes, my lord, it would be
Well, my understanding of what you've said so far, looking at page 38, it would be the area of land within the fencing. And on page 39, it would be the area of land covered by the tank. Is that right?
yes, my lord.
And we don't know when the fence went up, when the area of land within the fence, we don't know for how long you've actually had that fence up for, or when that new tank was put in place. Whether it was 12 years ago, whether it was 20 years ago.
No, my lord. We were just dealing globally with that particular area in addressing the court. In other words, the old tank and the new tank, which are in the same vicinity, is no dispute, I think, as to the fact that they're, located next to each other. But and that's borne out by the evidence, because by her own admission, Lords and my lady, nobody speaks to any other tanks on any other part of the island.
Yeah.
Yes. Thank you.
Those are the only tanks that are referred to in the evidence. And thus, that's why we say it was reasonable for the learned judge to find that the 1983 memorandum was applicable to that particular area. And
Now, I think you were assisting us with Section 38 of the Limitation Act.
yes, my lord and my lady. The last point that I'd make is with regards to Section 38. As I indicated, the Court of Appeal, my learned friend in her submission speak to the fact that the Court of Appeal did not rely on this as part of their determination. However, they do make reference to it. And we say that, first and foremost, their interpretation of that was incorrect, in that we do not, we submit that.
Sorry, when you say the Court of Appeal didn't rely on it, I mean, they have a section of their judgment at paragraphs 102 to 107.
I'm only referring to the written case of my learned friend.
Right, but what's your position?
And my
seems
position is that they do refer to it and it must be addressed.
Yes, it seems, on my reading of their judgment, to be an alternative basis on which they felt that they were able to dismiss the appeal. Is that a fair reading?
Yes, Lord.
Yes, all right.
And so that's why I said it must be addressed.
You do need to deal with it, yes.
And as it relates to that, we say that the clock did not reset by the payment of the $20,000. We say that Section 38 shouldn't be read in a vacuum. We respectfully submit that on a reading of Section 16 of the Limitation Act and also Section
Where, can you help us? Where do we have in the bundle Section 16 and Section 38?
Section 38 will be found at page...
It's 1157.
1157.
Thank you. And you wanted also to show us Section 16, I think.
Yes,
That is section 16.
Oh, sorry. Oh, that's 16, yes. You were going to give us a reference for Section 38, but presumably it's further on in this document.
The paragraphs that I would like to take this honorable board to would be Section 16 of the Limitation Act,
Yes.
Section 24, and which is at 1161. Section 25, which is also at 1161. And for the purposes, Section 38 is found at page 1166.
Thank you very much.
And I guess to start off with Section 38, just to quickly read, where there has accrued any right of action to recover of land or any right of a mortgage of personal property to bring in foreclosure action in respect of the property, and the person in possession of the land or personal property acknowledges the title of the person to whom the right of action has accrued, or and then it goes on to say the right shall be deemed to have accrued on and not before the date of the acknowledgement or payment. Now, we would highlight the word at the very outset of 38.1, where there has accrued any right of action. And it's our position that by operation of law, the respondent no longer had a right of action. And the reason why we say that is, if we go to paragraph, start off with 16. 16 says, no, and this is 16.3, no action shall be brought by any person to recover any land after the expiry of 12 years from the date on which the right of action accrued to such person, or if first accrued, to some other person through whom such person claims to that person. And then if we skip to 24, for the purpose of this act, a right of action to recover land shall not accrue and shall not be deemed to accrue unless the land is in the possession of some person in whose favor the period of limitation can run. That's 24 months. And then the most important part, Lord, for the point that I'm trying to make, is vesting of the estate or interest in adverse possession. It says, at the expiration of the period described by this act, which is 12 years, for any person to bring an action to recover land, the estate or interest of that person in the land shall vest in the person who is then in adverse possession of land within the meaning of section 24. And so we say that, Lord, that's akin to your Limitation Act where it speaks to extinguishment. In other words, we say that upon the vesting of the land in the appellant, water and sewage, properly the respondent lost any right to an action by operation of this particular provision.
And when do you say that happened?
After 12 years had vested, Lord.
Which is
Which either would have been 1983, according to the memorandum, or worst case scenario in this instance, Lord, since 1995, which is from the evidence of Cyprian Gibson. In any event, the notice of...
Sorry. It was 1983 the start point of the 12 years. Is that what you're saying?
Yes, Lord.
So when did the land vest, if one takes that as the start point? Is that 1995?
1995. 1995.
Or you're saying, if you take it as a start point from Mr. Gibson's evidence, which was, I think, 1995 when he started work,
Yes, Lord.
and then that would, you say, take us to 2007?
Yes.
All right, yes.
And it would have vested or extinguished any interest or right or possibility of the respondent. And the only other point to be made on that, Lord, is...
And as I understand, you're developing now, I think it's paragraph 47 of your written case. The title was, on this part of the argument, title was entirely distinguished under the Limitation Act.
Yes, Lord.
And the court's researchers suggested that there is authority that suggests it is supportive of you, if it's applicable in the Bahamas and is correct, that if once title has been extinguished by adverse possession, it can't revive. And I think
the position certainly appears to be prior to 1995, is that if title is acquired, if adverse possession is established, it doesn't just bar a remedy, it transfers title, which you say is also the effect of the new 1995 provision, and it title can't be revived or in some way retransferred back simply by acknowledgement. And
Yes.
There's a passage in McGarry and Wade dealing with the old 1883 Act, I think it was, 1833 Act.
so. This is
used to apply in Bahamas.
We're raising this point really so that Mrs. Roll has an opportunity to assist us with that if she wants to. Do we have copies of the case and the passage in McGarry and Wade? We're going to distribute the authority that the court identified for itself and the copy of the passage from McGarry and Wade. As I say, it's so that Mrs. Roll will have an opportunity to look at it over the short adjournment.
Yeah. And so, and just to be clear in mind, what this passage is dealing with is obviously the position in the UK about the expiration of the period of limitation. And sorry, I'll wait until they're distributed.
your wishes.
So those have been introduced as potentially supportive of your submission in paragraph 47 of your written case. By all means, look at them over the short adjournment, but I think if you wanted to say anything particular about them, probably you would have the opportunity to do that in reply, unless there's anything you wanted to say now.
No, no. I mean, basically, I think it makes the point that I was trying to articulate.
Well, I mean, this was the position. I think it seeks to explain the position in the UK and the position which I think may have existed in the Bahamas probably prior to the statutory intervention in 1995 under the Act.
That's right.
As I understand it, which is that prior to 1995, the 1833 Act applied to the Bahamas, and the law was as in the UK, which is you can't revive Title once extinguished by adverse possession.
Once it's been,
And my understanding is you say that's the same.
as
It's the Consolidation Act of 1995 didn't change that.
that's right. And just two more points.
Yes.
The last one is that in our written case, we speak to the issue of res judicata. I would
Where are you referring to in your written case?
This is in respect of the same, we say that the Court of Appeal erred in relying on this provision, Section 38, and considering the
Yes, I was asking for assistance. Which paragraph in your written case are you now referring to?
You can turn to page 1044, 1044.
Yes. Paragraph. 53, is that what you're referring to?
Paragraph 53.
Yes.
And so we rely on that provision, I mean, those submissions, Lord. And just quickly, the last point, going back a little bit, during the course of the trial and also contained in the Court of Appeal decision, much ado is made about the evidence of Mr. Gilbert Thompson, and the fact that it appears in answer to our question as to the documentary title, and the fact that there's no document that demonstrates how Albert Braynen came into possession of, or came into ownership of the property. Much ado is made about the evidence of Gilbert Thompson in that he spoke to that being the only document purporting to give title, despite the way in which my learned friend and also the Court of Appeal sought to interpret that one statement. We respectfully submit that if you look at the body of his evidence contained inside his written statement and throughout his cross-examination, you would see that he made it very clear that that document, the 1963 conveyance, was not a good root of title, that it wasn't worth the paper it was written on. And the last point, to that point, if you just bear with me, because I think it's crucial. the crucial point, during cross-examination, 2 points to be taken away from it. At page, at page 461, and starting at paragraph 24, this is the evidence of Mr. Gilbert Thompson on behalf of Water and Sewage. And I think this is very telling of the case presented by the respondent. He says, I could prepare a document right now purporting to own Atlantis. Atlantis is a very large, famous resort in the Bahamas. Now, it would be a document whereby I'm saying I own Atlantis, but there would be no documentary connection between the document, that document, and the real property owner, I submit, known as Atlantis. And then, more importantly,
But
He
somebody
said-
does own Atlantis, presumably.
yeah, but it's not that document that he prepared, though. He's not the true owner, he's saying.
Yes,
He
but
could prepare
in
a
your
document.
case, he could go and build a house on there, and when the owner said, excuse me, what do you think you're doing? He could say, well, prove that you own this going back to 1781, and it's got to be properly described in your conveyance. I mean, is that the point that somebody was making to him? That
The point that he was making in this is simply, I can write on a piece of paper that I own this building here, but it's not worth the paper that I wrote it on.
I'm not sure why you're showing us this. This seems to be a witness making a legal submission. What are we supposed to take?
The point that I was making was that the Court of Appeal and also the respondent rely on the one paragraph from Mr. Thompson to support the position that their 1963 conveyance is the only documentary title.
So which paragraph in the Court of Appeal are you referring to?
Right?
You said the Court of Appeal rely on something from Mr. Thomas, and I was saying which paragraph are you now referring to in the Court of Appeal's judgment, just so we can follow what you're saying.
This is inside our commission.
71.
In any event, my lord, just so I don't miss the opportunity to reply, I'll just take you to one final point with this respect, and that's simply the evidence is at page 463, paragraph 2. And the question...
463.
463, and I just
Line
want to...
2?
Line 2, starting at line 2. The question was asked of Mr. Thompson, and your position then is that the conveyance would have no validity whatsoever, and he says none whatsoever. And I guess, if anything, I may tidy that up a little bit more for you, but I would allow my learned friend to speak.
Yes. All right.
Apologize
Does
for
that,
going over.
well, as I say, that will come out of your reply time. So I think we'll allow you a few minutes additional reply this afternoon to make up for the time that we lost this morning. And so I think that if you've concluded your submissions,
Yes.
we'll call on Mrs. Roll at this point. But just so everyone knows, Mrs. Roll will be able to go this afternoon till 15:50, and then you will be able to reply for 15 minutes after that to 4:05. Yes, Mrs. Roll.
I'm obliged, my lord. My lords, my lady, good afternoon. The written case for the respondent is at page 1047. And before I begin, I do note that there were a number of very specific questions put to my learned friend, in respect of which it occurred to me that there were some concessions made. And before I begin, and I can decide if I should streamline my response having regard to those concessions. I just want to be sure that it is accepted that these concessions were in fact made. And the specific question, if we were to go to the judgment of the Supreme Court, and that judgment starts at page 687. And at the time when the question was put to my learned friend, we were looking at paragraph 143, which is on page 712.
Yes.
And the specific question that was put to my learned friend was whether or not he accepted that the learned judge erred when she relied on section 3.4 of the Conveyancing and Law Property Act. And I think he said he did.
Yes, and he says it doesn't make any difference because his case is different from that.
And so
we don't need to take up time, I think, on worrying about that.
that having been the case, then I will start my submissions by saying this. When you look at the judgment and the determination of the learned judge as it relates to the documentary title of the respondent, her rejection of the respondent's documentary title was predominantly based on section 3.4, and to a significantly lesser extent on the determination that the 1963 conveyance did not have a proper description. And the reason I say that, Laws, is because if you start at paragraph 128, you see the course of investigation that the learned judge was about to embark upon, culminating with paragraph 142. So at paragraph 128, that's on page 710, the learned judge says, and I read, "The defendant claims that the plaintiff does not have good title to the property because of the defects in her title documents. In the wake of this claim, the documentary title of the plaintiff must be examined in order to determine if the plaintiff's title to the property is good. The defendant allegedly has 2 water tanks and a water storage facility on the property in issue, and they had them on the property from at least 1983. And so in paragraph 128, you see the judge accepting essentially the argument of the defendant that the respondent's title is not good because of these defects. And then in the paragraphs that follow, my lords and lady, she then proceeds on the process after having identified section 3.4 at paragraph 129. She then engages in the process of investigating that case that had been put to her by the defendant, the appellant, for present purposes. She then culminates at paragraph 143, where she says, having identified, and I think before I go to 143, I will emphasize that at paragraph 140 specifically, 137, 138, she makes specific reference to what she deems these defects to be, i.e. 140, the large gap prior to the 1963 conveyance. And then she sums up her investigation at paragraph 143, where she says, given the aforementioned inaccuracies cited in my investigation of her title, inclusive of the lack of a description of the property in the 1963 conveyance and the lack of a plan, I am not satisfied that the plaintiff can prove a good and marketable documentary title to the property as is required to be shown by section 3.4 of the Conveyancing and Law Property Act. And so the point I'm making is that the rejection by the learned judge, by the trial judge, of the respondent's title, documentary title, was predominantly based on this conclusion that it was not a good and marketable title, as is required, according to her, by section 3.4 of the Conveyancing and Law Property Act. Now, the learned friend has accepted that as an error, and I think the Court of Appeal determination in Ocean Estates and Pindle demonstrates that, because given the learned friend's, again, concession that this is not a vendor-purchaser summons, it's not a vendor-purchaser relationship, whether or not there's a good and marketable title, as is envisaged by section 3.4, whether or not to use the verbiage from Ocean Estates and Pindle, this is a title that can be forced on an unwilling purchaser. It's not the issue. And that is the predominant, if I may go so far as to say, the gravamen of her determination and the rejection of the respondent's documentary title. Now, admittedly, there is a reference to the 1963 conveyance not having a proper description. So what I want us to do is to look at what she actually says about that, whether she fleshes out that complaint in any degree, and we say that she doesn't. So let's start at paragraph 137. And that's on
Well,
page...
so just in terms of the structure of her judgment, I can see the point that you're making based on paragraphs 128 through to 143, that is focusing, it seems, on section 3.4 of the
Yes.
Act. But at 144 and following, she goes on, and in paragraph 147, she seems to be referring to the common law concept of root of title. Is that not right?
Indeed, Lord, that's what I was about to do.
And indeed makes points in that section of her judgment about the adequacy of the 1963 conveyance and the will.
Indeed, Lord. In fact, I was about to do that.
All right.
She speaks to the process that I'm endeavoring to now do, my Lord, is to take the board to examine what she in fact said, if anything, about this lack of description in the 1963 conveyance. And I will preface my submission by saying she really doesn't condescend to why she arrived at that conclusion. So if you look at paragraph 137 to start with, this is the first place where we see that there's reference to the conveyance itself in that capacity. By the 1963 conveyance, Loretta Braynen then purported to grant and convey to Carl Braynen 660 acres, more or less, being a portion of 860 acres of tract of land granted to Joseph Evans and situated in the settlement of Mangrove Key, Andros, between Middle and Southern Bight, more particularly described in the will of William Sweeting, late of Mangrove Key, Andros. There is no plan attached to this conveyance. She then picks it up again at paragraphs 144, over on page 712.
Well, doesn't she pick it up first at 138? Because having noted that the conveyance cross-refers to the will of William Henry Sweeting.
But in 138, she's speaking of the will of Carl Braynen.
Yeah.
Right, I see.
Yes.
Right, okay.
So she doesn't say anything else about the will of William Sweeting. That's the point I'm about to go and make. So at 144, she now goes to canvass the
Well, hang on,
authorities.
what about 140? She says, review of the title documents reveals a large gap between the Crown grant to Joseph Evans and the Sweeting will.
Yes.
There is no evidential connection between the two, and it begs the question of how William Sweeting came into possession of the property, etc., etc.
And in that paragraph, Lord, I respectfully submit she's making the section 3.4 point. She's saying, she's speaking of the gap and the inability to demonstrate how Albert Sweeting came to acquire the property. So that's her examination of the title. She's not speaking about the lack of description in the 1963.
But even if at common law if she's right at common law to look at the 1963 conveyance, which you say is your client's root of title,
Yes.
it refers itself to the will of Henry Sweeting.
Correct.
So do you not have to look at the will of William Sweeting for that?
Well,
Absolutely.
I think you're making the point the judge isn't looking
The
at
judge didn't do it. That's the point I'm making.
Henry Sweeting.
And the Court of Appeal did, as I will endeavor to demonstrate.
Okay.
So we had a discussion this morning as to whether or not, when you compare what's provided for in the will of William Sweeting, in conjunction with what's provided for in the
I see the point.
1963 conveyance, you reach a conclusion as to whether or not together it amounts to a proper description. But the judge didn't do that.
Yeah, I see the point.
Yes.
Yes.
Well, that may be a convenient moment. If that's right.
Yes, yes, ma'am.
We'll adjourn there and resume at 2 o'clock.